Welcome to Fasken's 2023 mining series, our 13th consecutive. I'm Michael Barassa, and I'm part of the Fasken Global Mining Group and a partner in the Toronto office. Today's session is our first of 9 sessions, which continue until Tuesday, March 7. Please refer to the slide on your screen for some housekeeping items. And with that, now I'm going to turn it over to my colleague, Tracey Cohen, the moderator for Avoiding Litigation, Litigation Risk Spotting for Mining Companies, the session, and who's going to introduce today's panel. So welcome, Tracey.
Thank you very much, Michael, and welcome everyone. It's a pleasure to be with you here today. We have a fantastic panel today talking about litigation risk spotting, with the intention being that if you can spot the risks, hopefully you can avoid them. And we have a stellar panel joining us today, a combination of Fasken team and PwC team. So thank you to everyone for joining us. I will briefly introduce everybody, starting with the Fasken team and moving from east to west. We have Jean-Philippe Mikus in our Montreal office. He practices technology and intellectual property law, and is an expert in trademark and advising on global trademark strategies in all sectors, including the mining sector. In Toronto, we have Rahat Godil, who is a litigator specializing in complex commercial litigation and arbitration, and regularly advises clients both in the litigation and arbitration context. And with me in Vancouver, British Columbia, is Dani Bryant, who is a member of our litigation and dispute resolution team. And she focuses primarily on Indigenous environmental and regulatory law and advises regularly in respect of ESG issues, which is one of the primary things we will be discussing today. Joining us from PwC is McInally, who is the Managing Director of PwC's Forensic Services Practice in Calgary. And he is a CPA and Certified Fraud Examiner, will be discussing anti-bribery and corruption primarily today. And finally, we have Adrienne Wong, who's the Director of PwC's Deal Practice and specializes in advising clients, both buyers and sellers, on the pricing mechanism and financial aspects of their transactions. And she will be helping us in terms of pointing to some contractual terms that when you're negotiating a contract can give rise to litigation issues down the road. So thank you all for agreeing to join us today. And I am in Vancouver, as I said, in our commercial litigation group in Vancouver. So thank you all. And first of all, we're going to start with Rahat today, who I'm going to turn it over to Rahat to take us through some issues that arise in the context of securities and directors' duties.
Thank you, Tracey, and good morning, everyone. I'm going to be taking the time that I have today to highlight some of the risks that mining companies regularly face in 3 areas. The first risk I will be discussing is the risk of potential investor-state disputes and international commercial disputes. The second area I will be speaking about is the risk of non-compliance with regulatory disclosure requirements. And the third area that I'll be covering is the risk of litigation against directors of mining companies for breach of potential fiduciary duties. So with that background, the first thing I want to talk about is the risk of potential investor-state disputes and international commercial disputes. Mining companies and mining operations, as you all will know, typically involve long-term capital-intensive projects. They also often engage parties from different jurisdictions. Canadian mining companies, for example, routinely invest in foreign jurisdictions, routinely run their operations in other countries, including in jurisdictions where the regulatory system might not be as robust as what we're used to here, or the regulatory landscape may be evolving. And in this context, all kinds of risks and uncertainties can arise. For example, as a result of expansion activities or development activities. There's also risks involved with discovery of new minerals, or where you're undertaking a new project or a new investment. And it's really the last piece that I want to focus on for our discussion today. When you are undertaking a new investment in another jurisdiction, one of the things that we highly recommend doing right at the outset is undertaking an investment structuring review and thinking about whether there's a treaty, an investment treaty that you could benefit from. And the reason for that is investment treaties can provide protection against a number of risks, including risk of potential expropriation by the foreign country, risk of discriminatory treatment, unfair or inequitable treatment, and investment treaties can also facilitate free movement of capital in and out of the jurisdiction. It's important, therefore, at the outset, thinking about, is it a way to structure your investment to take advantage of that treaty, whether you're in a country that you can take directly benefit from a treaty, and if not, there might be ways to structure your investment, for example, by incorporating a subsidiary in another location and being able to take advantage of a potential treaty in that way. If protection of treaty is not available, the other thing that should be given thought to mitigate some of the risks is thinking about potential clauses to include in your investment contract. For example, an investment contract may include provisions that can protect investors from changes in law or regulation in the country they're investing in that might adversely impact their interests. You may also be able to include a provision in your investment contract that provides that the host country cannot unilaterally change laws or nationalize a project, and there might be provisions to protect and enforce your rights if you need to. From a commercial perspective, so that's the investor state context. From a commercial perspective, again, because players in the mining industry are regularly engaged with parties in different jurisdictions, there is an enhanced risk of disputes arising with international parties, and a risk that if you haven't agreed otherwise, you may be faced with a situation where you either have to commence litigation in a foreign court or respond to litigation in foreign court. And this may not be ideal, particularly if you're dealing with a counterparty in a jurisdiction where there may be perhaps concerns about corruption or lack of independence of judiciary, or there might just be local peculiar laws that you might otherwise be able to avoid. And sometimes there can be issues with enforcement. Enforcing a court judgment might not be as straightforward in other jurisdictions. In order to mitigate these types of risks, we suggest that serious thought should be given, again, at the outset of your relationship, thinking about whether it makes sense to include an arbitration clause in your commercial contract. Arbitration can offer a number of significant benefits and advantages, including, for example, flexibility of process. There can be cost and time efficiencies. It also can allow you to agree on decision makers that have subject matter expertise and be particularly suited to dealing with typical mining disputes. And an arbitration award is generally more easily enforceable than a foreign court judgment, and from that perspective could be advantageous as well. That's the investor state and commercial dispute context. I do want to take a couple of minutes to also briefly talk about the risk of non-compliance with the regulatory requirements. Mining in Canada, as many of you will know, is subject to significant disclosure requirements, and it's important to be aware of and ensure compliance with those requirements, because non-compliance can have a lot of different consequences. They can lead to regulatory action and proceedings. They could result in charges or enforcement orders under securities legislation. You could be liable to pay fines and penalties, and there's also risk of potential civil liability or a class action proceeding. The requirement that I want to highlight today in terms of the regulatory landscape is the disclosure requirement. Generally speaking, public companies, including mining companies, have to regularly provide the public with certain information about their activities and their financial status. Those obligations are referred to as continuous disclosure obligations. It includes a preparation and filing of things like financial statements, disclosure of material contracts, management discussion and analysis, and also disclosure of material changes. So essentially any information that could be material to investor decision making has to be disclosed. If there is a material change, for example, from exploration results and developments, or change in corporate structure or a joint venture agreement, there is an obligation to immediately issue a news release and then file a material change report within 10 days. Those are standard requirements that all public companies are subject to. The other requirement to really keep in mind is additional requirements that companies engaged in mineral projects are subject to under the National Instrument 43-101, which sets out sort of the minimum standards for disclosure of scientific and technical information concerning mineral exploration and projects. You do want to be aware of these requirements as well. And one of the key ones here is that disclosure relating to scientific and technical information has to be provided or prepared under the supervision of a qualified person. So selecting a qualified person who can review and approve this disclosure is critical in order to avoid potential regulatory reviews or other regulatory consequences or legal liability. The third area that I promised I would talk about is potential risks and conflicts that directors of a mining company might face and want to be mindful of in the interest of avoiding potential litigation. Directors of mining companies, just like any other company, they're fiduciaries to the company and owe fiduciary duties of loyalty. What that essentially means is that as a director, you have an obligation to act honestly and in good faith in the best interest of the corporation. As a director, you have to put the company must put the company's interest ahead of your own interests and avoid conflicts conflicts between the interest of the corporation or any other opposing interests. To provide some context and examples about the types of scenarios in which this could arise and potentially lead to an allegation of breach of duty and potential litigation, are situations where, for example, a director has been nominated to the board by a shareholder, and there's then a lack of alignment in the interest of the company and the interest of that shareholder, as a result of which the director is potentially in conflict in terms of whether to promote the interest of the company or to promote the interest of the shareholder that had appointed the director in the first place. In those situations, it's very important to remember that directors do have to act in the best interest of the corporation, and acting in the best interest of the corporation is not always synonymous with acting in the best interest of the shareholder, including a majority shareholder. And disobeying even a majority shareholder is not a breach of your fiduciary duties. Another example or scenario where this might arise is where a director is also a shareholder or employee of the company, or where directors are involved on boards of multiple companies. In that situation, you can also see that some potential risks could arise. There is no prohibition or conflict in terms of you acting as a shareholder of a company and also acting as a director. But again, I think the key to remember is where you're a shareholder and a director, your obligation as a director to promote the interest of the company must always be ahead of or a priority ahead of your interest as a shareholder. And again, no prohibition also on taking multiple board appointments, but if you're going to do so, you do want to be vigilant about fiduciary obligations that you owe to each of those corporations, and you want to be mindful about making sure that there isn't any conflict arising from that situation. The last thing I want to briefly mention is in addition to the duty of loyalty is the duty of confidentiality that directors also owe. Essentially, board members are required to not disclose information that they have learned in their capacity as directors, and this would include all material information that you have learned about the corporation's activities, including any deliberations of the board members, any statements made by other board members in your meetings. Those are all subject to confidentiality, and you want to ensure that that's not shared with anyone outside of the company to avoid potential allegations of breach of duty in that context. I will stop there. I know that was a lot to digest, but I will ask my fellow panelists now to share some other risks.
Well, that's fantastic. Thank you so much, Rahat. I think that any one of the speakers today could probably take up the whole hour and a half talking about the risks and potential ways to avoid them in the specific areas that we're discussing. And hopefully this will give the audience an understanding of the things to watch for and to look into more deeply. Just to pick up on a couple of things that you mentioned, Rahat. Firstly, just in terms of the duties of directors and this dual roles that directors sometimes play, where you have a nominee director. And one potential way of avoiding that risk is to have a shareholders agreement and to make sure that you have an understanding in place at the outset of the relationship as to, you know, what are the confines of the duties, and when can you share information, and when do you have a duty of candor to tell the board things that you know that the shareholders are duty, and when you don't. Otherwise, you can sometimes be in a situation where you're left to say it was implicit in the understanding that we were appointing a nominee to the board. One other question that sometimes arises is, when a director ceases to be a director, do they have those ongoing duties or not?
Good question, Tracey. And no, it's not a simple answer that you're no longer the director and hence all duties have come to an end. Obviously, if you step down as a director, you are no longer continuing to be a fiduciary going forward. But to the extent you may have information you have gathered before stepping down, you can't just use those use that information. And courts have there've been a number of cases that have sort of addressed that point where directors, for example, might have become aware of a corporate opportunity in their role as a director, then stepped down to take advantage of that opportunities, and the court found no, you can't because you had learned of that opportunity simply in your role as a director. You continue to be you can't just sort of ignore your duties now that you've resigned. Or there have been cases where, for example, I think it was last year, a dispute between a gold mining company and a director where the court granted a permanent injunction to a former director because there were concerns, egregious breaches of fiduciary duty, breach of confidentiality. The director was in possession of confidential information, and the court sort of granted an order restraining them from doing anything to breach those obligations going forward. So these obligations can carry with you even after you've stepped down. So it kind of depends on the circumstance.
One other thing I just wanted to pick up on is in the arbitration context, and obviously mining companies often are doing work in all different parts of the world. And one benefit of an arbitration clause is that you can specify both the seat of arbitration and the place of the arbitration. So if you have mining executives in Canada who don't want to have to go and travel to a foreign jurisdiction to attend an arbitration, is that a way of potentially avoiding that?
Yes. So arbitration clauses, as I mentioned, it's a great, it's something that should definitely be considered in a commercial context. And you can certainly specify what the seat of arbitration is going to be, which will basically determine your arbitration procedure. And the seat of arbitration doesn't have to be the same as the venue of your arbitration. So depending on which jurisdiction you're dealing with and where you're located and what kind of potential disputes might arise in a proceeding. You could choose a seat that is different from your venue, and the hearing can take place anywhere, but you could take advantage to the extent certain procedures or in certain jurisdictions provide benefits. You could take advantage of that without having to be restricted to that location as also being where the arbitration is eventually heard.
Thank you, Rahat. I think that's a good segue into our next topic, which I'm going to ask Casey to speak about fraud and corruption and what can be done to avoid potential risks arising from those issues. Thanks, Casey.
Yeah, thanks, Tracey. So as Tracey mentioned, I'll be speaking today on anti-bribery and corruption. I'll kind of focus on three pillars. Number one being why we're focusing on anti-bribery and corruption. Number two, the risks and challenges to mining companies specifically. And number three, and the most important, what can companies be doing to combat corruption? So why is anti-bribery and corruption important? So beyond its obvious impact on the economic development, inequality, poverty, social division, it's the law. In Canada, we have the Corruption of Foreign Public Officials Act, or the CFPOA for short, which essentially prohibits a bribery of foreign public officials. You may be familiar with the FCPA in the US or the UK Bribery Act in the UK, which are very similar. Generally, any Canadian citizen, permanent resident, or companies organized under the laws of Canada or its provinces are subject to the Act. I should also mention here that Canadian companies may also be subject to the FCPA in the US if they conduct business in the US or are traded on US exchanges. That's an important point, especially given the difference in enforcement, the US being much more active than Canada. The second bullet in the first pillar there is the impact of noncompliance. Rahat kind of touched on this briefly, but regulatory fines and penalties are significant. There's many cases in the news. Glencore is a recent one. If you look up Glencore, they face over $1 billion in fines and penalties. Beyond that, investigative and legal costs, reputational damage, share price, shareholder value, significant impacts for companies. And beyond the companies, individuals also have an impact as well. Regulators look to charge individuals in these cases, and they can face imprisonment of up to 14 years under the CFPOA. Number three, there's just an increasing demand, social demand for transparency and accountability with respect to ESG. ESG is really kind of setting the stage for this, and AB&C, anti-bribery and corruption, is a major component of that. Dani will speak more on ESG, so I'll leave it to her. The last bullet there, which kind of touches on pillar two, it kind of blends in there. The exposure for mining companies to bribery, to foreign bribery, is high. It's explained by specifically the first two risks in pillar two, which I'll get into now. So number one, country risk. Obviously, Rahat mentioned this as well. The companies, or the countries that mining industry, the mining companies operate in, have a high risk of corruption. They have different norms, ways of doing business. In some countries, corruption is simply endemic, and it's ingrained in everyday life. The background on my slide here is Transparency International's corruption index, which essentially ranks countries on the perceived level of corruption. If you want to take a look at the countries in which your company may be operating in and the perceived levels of corruption, I'd urge you to take a look at their website. Number two, in the middle pillar there, the government touch points. So the mining industry has many government touch points, whether that's licensing and permitting, sales to government agencies or government funded organizations, joint ventures with government linked organizations, or social development programs, which is prevalent in the mining industry. They're often under pressure to give back to local communities, for example, building schools, playgrounds, etc. Those situations can pose a significant bribery and corruption risk to the entity. Third, autonomous foreign operations, something that's not solely related to the mining industry, but it is a situation that is specific to that involves the mining industry. For example, monthly cash call requests. We see this where the corporate entity will send cash down to their foreign subsidiaries or foreign operations, often with a lack of detail or a lack of understanding of exactly how those funds will be used and whose hands those funds will ultimately get into. The last bullet in slide or in the middle pillar there is an interesting one perhaps for you, and a different way of looking at it, but it speaks to the practical challenges in preventing bribery and corruption. And that is, bribery is a revenue generator. What do I mean by that? Let me clarify. So the payment of bribes typically results in positive financial benefits to the business, whether that's obtaining key licenses, permits, or securing additional revenue from the sale of multi-million-dollar contracts, as I mentioned. So bribery is different in this way from other forms of fraud, which are typically acts against the business, where the result is a negative, often a financial loss to the business. Because of this difference in the inherent incentives between bribery and other forms of fraud, bribery mitigation programs have often garnered less attention than safeguarding against other forms of fraud. But at their core, businesses, including its stakeholders, employees, and third parties, are incentivized based on the success of the business. So if a bribe stands in the way of that success, it puts the business, employees, its third parties in a situation where they must forego the business success and potentially their own financial incentives to do what's right and legal. It may sound like an easy decision for some, but I can tell you the incentives and the pressures on individuals play a significant role. I'll use an example to illustrate this. Consider the differences in thinking of an internal compliance staff, an internal sales director, and a foreign sales agent if faced with a request to pay a bribe or a situation which has a heightened risk of a bribe being paid. The compliance individual stands nothing to gain from paying a bribe, and in fact is incentivized based on their position within the organization not to pay it or not to allow it to be paid. On the other hand, a sales staff or third-party sales agent whose sales commission depends on the sale is directly incentivized to pay it or to turn a blind eye to the risks. Big caveat here. I'm not saying every individual whose compensation is tied to the sale is going to pay a bribe, but rather I'm highlighting the importance for companies to appreciate the heightened inherent risk when incentives are involved. Companies should focus on these areas and consider independent oversight from bodies like compliance or internal audit to limit the opportunity for bribes to be paid in these situations. That's maybe a good segue into pillar number 3. So how can companies combat corruption? Given what I've just spoke on, how do they combat it? So number 1, companies need to have a robust and effective compliance program. It's not enough to have a few policies and hope that staff are following it. Effective prevention is much more involved than that. And it starts with the tone from the top. The first bullet in the pillar there, the third pillar, the board's role specifically. The board has a significant role in setting the tone from the top. They're in a unique position of independence, and they can provide an unincentivized, unpressured oversight function, allowing them to ask questions that might otherwise have been overlooked. However, in order for boards to be effective, they need to be regularly trained on anti-bribery and corruption. They need to understand the risks generally. And then also they need to have regular updates from management on the specific ABN risks facing the organization and the company's efforts to mitigate those risks. The greater, what we find is the greater the transparency and communication between the board and management, the greater the appreciation of the risk of the board and the greater support the board gives management to make decisions that may jeopardize the company's success of securing a deal, for example, but it reduces the company's exposure to bribery. This support can have a profound impact on changing the culture within an organization. The second bullet on the slide there, risk assessments. This is a foundation of any effective anti-bribery and corruption program. Companies should be conducting regular anti-bribery and corruption risk assessments to gauge their current risk, as well as identifying emerging risks from resulting from new markets and business ventures. This is a baseline expectation of regulators. They expect you to be doing this periodically, regularly, and they expect the compliance program to be evolving and improving in line with the risks that you've identified. The third bullet in the third pillar there, and perhaps the most important to mitigate the risk of bribes is the management of your third-party risk. 79% of U.S. anti-bribery settlements in the past 3 years involve the use of third parties. It's just the way bribes are paid typically in foreign jurisdictions. So managing your third-party risk, there's a few elements to it. Number 1 being integrity due diligence, maybe an obvious one, but companies need to be conducting adequate due diligence on their third parties before engaging them. So tailoring the extent of your due diligence efforts based on the risk is often a good way to do it. It's not to say every third party you're gonna do steps 1 through 15 to try to understand that third party, but you can tailor your programs based on risk to spend more time where they need it. Some of the things we don't always see companies considering when they're conducting due diligence, which are practical considerations, is how is the business identifying their in-country agents or third parties? Are they being referred to by government officials, for example? That's an obvious risk. Are agents and third parties operating via established companies or as individuals? If acting as individuals, they have more autonomy with the funds that they're receiving from your company versus if they're acting on behalf of an entity which has its own controls in safeguarding the funds and how they leave the organization. Third, what is their in-country reputation? Who are they connected to? Why have they had past success? Again, some practical questions, but the answers or lack of answers to those questions can tell you a lot about that third party. Another area in third-party management that doesn't typically get enough attention that we see is during the contracting phase, specifically the involvement of an independent party like compliance in the assessment of the reasonableness of third-party remuneration. So compliance should be involved in this process. Typically, we see approval structures within organizations based on delegations of authority, which are sometimes solely based on financial metrics. So for example, if the contract is over $1 million with this third party, it requires a CFO to review and approve. What we try to coach clients on and get them thinking is more on the broader risk. So if you have an agent that's representing you in a foreign country and will be dealing with foreign officials, that poses a heightened risk of bribery and corruption. And it should be reviewed, the contract and remuneration, by compliance individuals who are more experienced in recognizing those risks than others within the company. So compliance can have a profound impact on this assessment and in the contracting stage. Like I mentioned, assessing the reasonableness of the remuneration when compared to the services, including the currency of the remuneration and its impact on the reasonableness for that specific country as well. When companies are assessing the reasonableness of the remuneration, typically by sales staff or by finance staff, one of the areas we often see overlooked is the structure of the remuneration, which is a significant risk for bribery and corruption. What I mean by the structure of the remuneration is whether it's commission-based, hourly-based, fixed fee. What we typically see in these cases is commissions are often used to facilitate bribes because of their opaqueness in the value associated with the services. If you think about it logically, how does a company truly understand whether the services of their, let's say, a sales agent is worth a 15% commission, for example? It can be a difficult question to answer, but it's one which would benefit from independent questioning and consideration by staff in a compliance team that are experienced with the risks of bribery and corruption. Compliance can ask questions like, does a commission structure make sense? Would a similar service in Canada or the country that you're operating in, performed by a lawyer, for example, be paid commission or hourly? Why should it be different in that country? What is the average annual salary in that country, and how does the commission you're paying that foreign agent compare? Compliance can also consider the nature of the agent services, which can tell you a lot as well. So how important is this agent to the deal, and why are they so important? Do they possess an in-depth knowledge of your product or service and have an ability to better articulate its value, or is their success based on their relationships? Obviously, relationships poses a greater risk and the need for greater scrutiny and safeguards. But essentially, at the end of it all, the independence of the compliance team and their understanding of anti-bribery and corruption risks makes them a key line of defense during the contracting before you're agreeing to things that may otherwise pose challenges down the road. Working together, we find compliance and the business help educate each other, and they foster a stronger relationship between the assessment of opportunity and risk. The last bullet on this pillar is monitoring and testing. The companies need to actively monitor their interactions with public officials. Again, something we see kind of a lack of within the organization. Sometimes they're monitoring their interactions with public officials themselves, but they're not really focusing on the interactions between their third parties and public officials. What we try to coach clients on is requiring periodic reporting, which can vary, but essentially you want to understand the interactions that your staff and your third parties are having, including the dates, locations, topics of meetings, who attended, the cost of business entertainment or hospitality provided to foreign officials. The list goes on. But it's essentially, creating that structure that requires regular reporting will provide the business some insights into the risks that may arise. Testing. Companies need to periodically test their operating effectiveness of their anti-bribery and corruption controls, specifically the key controls and the key aspects of it. One of the growing expectations we see amongst regulators is that they're expecting companies and they're pushing companies to now proactively monitor for ABC risks. And the way companies are kind of getting at that is using data analytics. So if you think about an organization, we have many forms of data. We have accounting records, we have vendor records, and they're really pushing companies to leverage that data to identify risks real time and have their compliance programs change and evolve as a result of the identification of new risks. I'll stop there and welcome any questions during the Q&A.
Thank you, Casey. And just to remind the audience that if you do have questions on any of the topics as we're going through, please feel free to type them in and we'll try and answer them either during the session or at the end. Just to come back, obviously this is a very this topic is very much in the newspapers and the spotlight these days, and I don't think anyone is questioning anymore whether a parent company in Canada can be responsible for the acts of its subsidiaries that might be operating in foreign jurisdictions. So if you have a parent company policy dealing with anti-bribery and corruption, how do you get your foreign subsidiaries to comply with that? Any thoughts on that?
Yeah, that's a tricky one, and that's kind of what I mentioned by the autonomy of those foreign operations. Is it can be a real challenge to implement your corporate policies and procedures and what you expect down through a foreign subsidiary. But I will say you can focus your efforts based on risk as well, right? So you may have many foreign subsidiaries, some operating in countries which are higher risk than other countries. You can tailor your risk assessment, your level of effort, and your level of cohesion based on the risks. So that would be number one. And then number two, you can help yourself by assigning compliance responsibilities within those subsidiaries and create the reporting structure from those subsidiaries with their responsibilities all the way up to corporate. Really, the more information corporate has and compliance individuals have, the better. So there's many ways to do it, but it is, like you said, Tracey, a real challenge.
So that takes us into the next topic, which is ESG, and Dani is going to continue this discussion with a bit of a different focus. Dani, do you want to?
Yeah, thank you, Tracey. And thanks, Casey, because you've also given a great intro to the ESG topics. So a lot of what Casey's already discussed applies to the other aspects of ESG. And when given the task of talking about litigation risk in the ESG world today, I decided that maybe what is best is to just go through a few of the trends that we're seeing in ESG litigation right now. I'd like to clarify that a lot of the cases that I'm discussing or claims that I'm discussing are ongoing or current or brand new. And so there's not necessarily a decision as to the liability of the corporations or the parties involved, but this is more to say that this is things you might expect, even if some of them are novel claims. So first off, I thought I'd talk about environmental claims. Greenwashing is the word du jour. It's the trend of the day for your ESG claims. And greenwashing is essentially overstating or overselling your environmental commitments, policies, or strategies. So the same concept could also apply to other aspects of ESG. So it could apply to your social policies as well. But we're seeing the most of them right now in the climate world. And so it's most often we see this, we're seeing claims of a company making false or misleading claims about its products or strategies. And to date, it's mostly focused on voluntary climate-related disclosures. But as climate disclosure requirements are implemented, this will also become more of a regulatory issue. So we are actually having another seminar focusing specifically on greenwashing. So I won't get into this issue too much. I believe the seminar is tomorrow, but I'll try and confirm that before the end of the meeting today. But right now in Canada, so far, greenwashing is coming up most with the Competition Bureau investigations. The Competition Act requires the Bureau to make investigations where a complaint is made and meets certain threshold requirements. So one of those investigations is of a major Canadian bank investigating a complaint that it made materially false claims about its commitments to the Paris Agreement goals and achieving net zero. And then another complaint was made about the Canadian Gas Association about representations that it made with respect to certain gases, including that methane was, I believe, more affordable than other home energy systems. Also, the Canadian Securities Administrators also identified that greenwashing is an issue in disclosures, that they're seeing companies make overly promotional ESG disclosures, and it warned of making such disclosures without providing sufficient evidence to substantiate the claims that you're making, and that they should be fact-based and balanced. So really don't oversell this, be really truthful and make sure that it's backed up by data and isn't too vague. We're also seeing an increase in environmental regulatory compliance risks. So increased investigations and enforcement regarding environmental compliance with permits, environmental laws, that type of thing. We're seeing governments put more resources into environmental and other regulatory compliance measures and increasing the size of penalties. So moving on to social risks. This could include things such as equity, diversity, inclusion, human rights, engagement with Indigenous communities or local communities. And a recent example is from last week. The SEC and Activation Blizzard, which is a gaming company, settled. Activation Blizzard agreed to pay $35 million toward novel claims that the company failed to adequately control disclosures, tracking workplace complaints, and violating whistleblower protection rules by the separation agreements that they had entered into with employees that were departing the company. So they based this on a failure of the company to collect and evaluate employee workplace complaints, which prevented management from having adequate information to assess whether disclosures concerning its workforce were fulsome, accurate, and not misleading by omission. And Activation Blizzard had identified as a material risk the retention and development of its employees, of high quality skilled employees. And so because it was connected to a material risk that they had identified, they should have had systems in place. There's also two cases in the social world that I just wanted to kind of highlight. One of them, Tracey and Casey mentioned earlier, or deals with an issue Tracey and Casey mentioned earlier, related to piercing the corporate veil of, can a parent company be liable for the acts of its sub? There was a number of these cases that came up a few years ago, dealing with this issue of how do you break or pierce the corporate veil with respect to allegations of tort or international human rights complaints of the sub. And so in order to pierce the corporate veil, the parent company has to have a level of control or management over the sub. And that can be shown as a fact dependent and can be shown by things such as the parent company developing corporate policies that the sub is supposed to implement, whether the parent company makes representations about its oversight of the sub, and whether the parent company provides training or support to the sub. So Casey's already identified the importance of having systems in place between the parent and sub where that is the case, where there is that relationship, in order to do your due diligence and make sure you have systems to prevent non-compliance with the policies. And so this may lead to individuals or plaintiffs suing the parent in a more favorable jurisdiction than the sub is operating in. And these can be they can sue for torts, so for things such as battery or intentional infliction of mental distress. They can be, and the Supreme Court of Canada actually recently determined that they may even be able to bring claims regarding non-compliance with international human rights obligations, which there was a split 5-4 between the Supreme Court of Canada about this, whether corporations could potentially be held liable in civil court for such claims. And it was really only deciding in concept, yes, they can be. So we haven't seen them found liable yet for such claims. And then I also wanted to highlight another decision from the BC Supreme Court last year, which was a claim where two First Nations who were claiming Aboriginal rights to fish in a river and Aboriginal title to the watershed in which the river ran. And they claimed that they were affected by a dam that impacted the population levels of fish within that river and within the watershed. And so they sued the corporate owner of the dam only. They didn't include the BC or Canadian governments, which normally Indigenous claims of Aboriginal rights are against government instead of private parties. The defendant ended up adding BC and Canada to the claim, but in the claim, the two First Nations alleged that the dam had significantly impacted fish in the river. And so they claimed the tort of nuisance, which is interference with property rights, based on their Aboriginal rights. And they sought an order requiring the defendant company to rectify the flow of the river by changing the flow out of the dam. And the court held that private parties can be held liable for substantial and unreasonable interference with the exercise of Aboriginal rights. So corporate or private parties can be held liable for nuisance affecting Aboriginal rights. And the court found that the dam's construction and use significantly altered fish populations and had had a profound impact on the First Nations rights. However, the defendant company was able to rely on the defense of statutory authority because the defendant's conduct in operating the dam and in constructing it was completely authorized by government. And it was the inevitable result of that authorization given. So it's important to note that strict adherence to permits and authorizations is necessary for that defense to apply and to show that there isn't a less impactful way of operating. So that's it. That's all I'll talk about, I guess, for social risk. As far as governance goes, I just wanted to touch on two recent cases. So I believe it was just last month, some minority shareholders of Shell sued Shell's 11 directors personally, claiming that they were personally liable for allegedly unrealistic net zero, Shell's allegedly unrealistic net zero plan. And a number of institutional investors are supporting the claim. And so the claim alleges that the directors breached their duties under the UK Companies Act by failing to act in good faith and exercise independent judgment and reasonable care, skill and diligence in creating Shell's energy transition strategy, arguing that it should do more to prepare for climate change and to adjust its business accordingly. I also just wanted to flag that recently a Delaware court held McDonald's chief people officer, so I guess their head HR person, had a duty of oversight. So this is an officer, not just the board, which entailed a duty to make good faith efforts to put in place reasonable information systems to collect information needed to make sound decisions. So again, kind of going to Casey's point about creating these systems so you have the information to be able to make sound decisions. And that he also had a duty to not ignore red flags, indicating that the corporation was going to suffer harm. So I think I've only got about a minute left. So things to think about to mitigate some of these risks. As I mentioned, several of these types of risk overlap with how you can mitigate, or how you can mitigate them overlaps with the systems that Casey has already talked about. It's important to develop board oversight of ESG issues. If the board isn't already looking at ESG closely, it should be, whether that's the whole board or creating a committee. But and you also need to create processes so that ESG filters through all aspects of the company. You also want to ensure that disclosures and advertising properly and specifically state corporate data, policies, and plans. And those statements should be specific and not vague. You also want to stay compliant with your permits and authorizations. And if you cannot, contact legal counsel immediately. And this can be done through the creation of systems to track, assess, and mitigate ESG risks, and regularly review those systems. You also want to stay up to date with ESG developments. As you can tell from the news every day, it's like there's a new ESG article. There's a lot of development in this area and a lot of new regulation coming into place. So you want to make sure you're up to date with what those are and how they may apply to your company. And also seek consent from and enter into agreements with local Indigenous peoples. And then finally, retain specialists, including legal counsel, to help you with ESG issues. If you're dealing with a climate issue, make sure you've got a climate specialist helping you. If you're uncertain about disclosure requirements, contact counsel about how you should be disclosing things. So that kind of is a broad brush look at what some of the trends are in ESG currently.
Thank you, Dani. We certainly gave you a tall order. This is an area of law that is evolving rapidly, and all kinds of interesting novel issues. And just to embarrassingly give the audience some insight as to the types of riveting conversations that litigators have, Dani and I were discussing shareholder behavior in the context of these claims, and whether it is intuitive that these are the kind of claims that shareholders should be supporting, given that it may have a negative impact on share value. But shareholders do seem to be more focused on these issues and willing to advocate in favor of them. So that's certainly a trend, I think. Is that a fair statement, Dani?
I think that that's a fair statement, and you can also see the trend through ESG investing. Like, I think that shareholders and ESG investors, like, they're obviously one and the same, but you can see that tension of how do you address ESG as a shareholder? How do you maximize value of the corporation? Are you thinking short term, medium term, or long term as far as what's in the best interest of the corporation? So complex issues.
And novel legal issues, which litigators find fascinating and clients definitely want to try and avoid. So good tips there for how to do that. And just to come back to the other topic or the other webinar on greenwashing is on Friday. It's not tomorrow. It's Friday morning or morning PST, but 12 o'clock Eastern time. So
great. And I'm going to do a plug for that because the speakers are excellent. So if you're interested in greenwashing, definitely check it out.
So thank you, Dani. And now we're going to turn to Jean-Philippe, who's going to talk to us about another thing that is rapidly evolving, which is digitization in corporations.
Well, thank you very much, Tracey. And so, I mean, I think it's an understatement to say that digitization or digital technologies are converging rapidly in mining. And in fact, some of the issues we've been discussing today can be solved in part, or can be helped along with AI, machine learning, a lot of these things. But generally, this is a very broad-based sector, and there's real value for these technologies in mining. So there are a lot of risks, but it may be a risk of ignoring these technologies and just not engaging with them and not implementing them. And just a few examples, in mining exploration, you can comb through geological information to identify the best drilling locations, through machine learning, deep learning, or other AI techniques, and that can bring significant value to shareholders. Autonomous systems have been known for a long time in the mining industry. I mean, there's the famous trucks autonomous trucks, but I mean, this is expanding to autonomous drilling, blasting, sampling, other things, and that minimizes risks to humans and optimizes processes. It can be simple things like mineral sorting, with smart sorting machines and with cognitive AI, just to need to increase yields or reduce environmental impacts if you can sort better. Real-time predictive safety, maintenance, and environmental monitoring is now possible through, if you include Internet of Things sensors on various machinery, and you can predict essentially and make these preventative maintenance at the appropriate time. And even basic things like HR management, scheduling, crew composition, rotations, all of that can be optimized through AI. And obviously there's a lot of positive aspects, but there's a lot of negative aspects for digitization projects. And often digitization projects, especially large scale projects, are wasps' nests for litigation. And often it could be simple things like which can get to take epic proportions. Projects going over budgets, timelines that are not respected, technical failures in the implementation, or just not meeting the targets. And often it's a combination of all the above. I mean, it's gone over budget 2, 3, 4, 5 times. It's the timelines are way over, and then half of the functionalities or benefits that were expected are simply not there. So these can be significant pieces of litigations, and the claims, if a contract is badly worded, the claims for simply additional fees or compensation can be significant from some of these players. And when we're in the field of AI, deep learning, robotization, all of these things, and especially AI, it can get complicated because it's all about learning, training, right? And AI and machine learning, as we're learning, even reading the papers, are really finicky technologies, especially when we have a black box approach where we don't really know exactly how the algorithms are functioning. What are they taking into consideration? How are they weighing the various factors? So it's difficult in that sense to predict the behavior, to see the failures in advance. And there's the possibility in AI of data biases. So essentially rabbit holes where the machine falls into that hole and starts pumping out wrong information or wrong directives based on data that's incorrect. And in fact, data biases can be even a client-side issue or a customer-side issue, because often in tech agreements, it's the customer, not the tech company, that's supposed to be providing the data and be responsible for its quality. So that is a significant issue. And if you're uncertain about what data should be going into this AI project, perhaps you should put the burden on your tech supplier, just to make sure that they put their hand in there and they commit to a certain level of engagement or results on that front. And even if we're talking about black box approaches, I mean, you should consider explainable AI, which is essentially, it's not that I don't think there's a specific standard at this point, but it simply means making sure that it's really an approach to make sure that the AI functions with fairness, interpretability, security, private, and in light of privacy issues. And especially interpretability aspect is important so that operators, people who are using the AI, understand how it works and are simply not just throwing data at a black box and not knowing how it's going to deal with it. Obviously, a basic mitigation technique often involves risk sharing on the fee side, and that's important to be considered on all significant projects. I mean, you should assume that a major digitization projects will go off the rails and will end up costing 2, 3, 4, 5 times more in some cases. So you have to deal in advance of how do you deal with these issues, and it could be reduced rates for excess work. It could be rollbacks, other mechanisms, success fees, on certain aspects. The ideal approach would be to have fixed fee project for tech projects, but that's fantastic if someone's offering that, but make sure you look at the scope of work. But in many cases, the tech provider won't want to commit to these kinds of things. And binding timelines, or making sure these timelines are really contractually binding, is also a source of risk mitigation. But it cuts both ways, right? Because if you're supposed to be if you as the customer, mining company, are supposed to be delivering certain things, and you may be liable because you're not meeting your own deadlines, and that happens very often in these types of complex projects. Another risk is that these projects entail the integration of multiple systems, because obviously what you want is create a data-rich environment in which you'll maximize the value of AI, machine learning, deep learning, and that entails the integration of multiple systems. And this is a pitfall, because it might require interconnecting multiple systems, and not only to capture data, but also to react by having the systems adjust themselves, for example, with robotization. The common issue is that the breadth of interoperability is overlooked in contractual documents. And clear language is required to allocate responsibility. Who's supposed to be making sure all the systems interoperate? If you have one vendor that's providing one aspect of the solution, who's in charge of making sure everything works together? I mean, don't assume that a single supplier can do it all, and don't underestimate the internal resources that will be required in terms of skill sets and availability. And it's important often at the outset to avoid failure to map that out with the supplier to understand exactly what is expected on the mining company's side. What kind of expertise do you need? And if you don't map that out properly, you're going to end up not being able to meet your own deadlines. Another general aspect is that digitization projects seem like a tech project, a purely tech project, but more often than not, it's about business process re-engineering. Because if you're implementing these digital technologies, you will be changing the way you do business. And many tech firms won't capture that dimension. And essentially, they won't give proper guidance on this business process re-engineering. And this may result in lag on the mining company's side, slippage on milestones, demands for additional fees because, we just figured out that we need to modify our processes. And therefore, the specs that were agreed to at the outset are no longer applicable. And often tech firms will use this as a defense if they are offside by saying, well, no, this is not our problem. The reason why we're late or it's more expensive is because you can't keep up with the project and you're not doing your business dealing with your business processes in time. And that's why we're late. Yes, I've been involved in a lot of mudslinging in these types of projects, if you're asking. Another aspect with tech is that there are a lot of promises that are being made in terms of increased productivity, efficiency, percentages. All sorts of numbers will be thrown out. All sorts of things will be stated in marketing pitches, and it's true. I mean, the prospects in AI or machine learning for improvement are vast. And again, I should mention it is this type of project should be something that should be contemplated by mining companies. And one important thing is really to make sure you're keeping track of these promises and keeping track of the benefits of what you're going to be implementing. Because often when we get to the contractual stage or even pre-contractual stage, what was in the original PowerPoint or a jazzy presentation with fantastic animation it gets lost, and you end up in situations where some of the promises or efficiencies that are being promoted aren't memorialized anywhere. And it's important to put these in the pre-contractual documents, the contractual documents. Obviously, there can be debates as to under applicable laws as to whether pre-contractual documents count or not. In some jurisdictions, such as the jurisdiction where I sit in Quebec, they are given some weight in litigation. But these are often important with the nuclear weapon of tech contracts. If things are really going sideways, which is trying to rescind the contract because of misrepresentations, which is something that a red button that often, if things go completely sideways, this is a red button that should be contemplated. And basically, the way you're going to be asserting this is by using these misrepresentations, or what representations made at the beginning. The last thing you want is to argue about these things. And even sometimes to avoid these kinds of issues, you can perhaps split up major contracts in separate phases that can terminate after a certain phase, and maybe have an initial pilot phase, in a certain, let's say, a certain facility or certain production line or certain area, where you can then get some additional a track record, and therefore perhaps obtain greater actual commitments on the efficiency side, for example, or the functionalities from the provider. And in terms of damages, complex systems that use AI or IoT are a source of considerable damage because there's more interconnectedness. And so it becomes both the benefit and the Achilles heel of these systems, because if it goes wrong, a lot of systems will be impacted. And it's you need to take this into account when you're stipulating minimum insurance requirements, for example. It may be that even if this project is worth $1 million, perhaps its impact would be for $5 million or even more. So it's good to have to make sure that you have insurance provisions that are really aligned, and perhaps and there's a strong tradition in tech to limit liability, for example, to 12 months of service fees. But perhaps it's good to try to push that up, or at least insist that the liability, if there is insurance coverage, will be capped at the insurance coverage. This digitization also creates new risks for cyber attacks, because often you will have, for example, even AI as a service. You'll have online platforms that will be getting some data, and the tech firms themselves will become a point of vulnerability. They'll be in a cog in a wheel. And often it's not enough that the hosting provider of this tech provider is certified. I think you have to take a standards-based approach to security with your suppliers, with regular vulnerability testing and remediation. And the implementation of AI, IoT, robotization go hand in hand with security. And it's often in these contracts unclear who is responsible for security and digitalization projects. So this should be clear at the outset, and get the necessary security expertise. And last point I'll mention quickly is that AI learns about your business. It learns about your processes. And often in mining, there's lots of trade secrets, because a lot of things are really done internally at the mine, and it's possible to keep trade secret protection, but the AI will be learning about your trade secrets. So it's a source of disputes is exactly what the tech provider can do with what the AI learns. Can it send it to your competitor? And this is something that's often overlooked in agreements, but with AI, it's especially important, and it's especially important to get a good wrap your head around the various concepts, because in AI you will have models, you'll have the code, you'll have process data, the raw data, and you need to wrap your head around which of these elements will include your sensitive information, and make sure you restrict that properly, just to avoid involuntarily granting rights and valuable trade secrets. And that's about it for me at this point.
Thank you so much. That was again a lot to cover in a short period of time. So one thing I have personally seen a lot more disputes emerging in the context of these digitization projects, and fixed fee contracts, quotes versus estimates, those are often issues that arise. And in addition to that, another significant issue that arises is if you get into a dispute partway through the project, who owns the work product that has been developed to that point, and can you turn it over to somebody else to continue with the project? So I think that's another thing that often is overlooked at the front end. I don't know if you've experienced that as well.
Yeah, I mean that is being able to pivot with another provider is a key issue, and often an aspect that's often overlooked is making sure that the agreement gives you access to the data, the algorithms, whatever you need to continue the project with someone else. And I think that's a very important aspect, just so you can continue that project with someone else. But there's a lot of tech providers are very reticent to give access to these kinds of things. And what you have to factor in is that even if you get access to this information, this code, these algorithms, there's a lag, in the sense that if you restart with another tech provider, it'll take them some time to ramp up and figure out what the last provider was up to. And so it is important to get access to these things, but sometimes you can't think that this is going to be a smooth transition from one provider to another. And what you can do as well is bind one of the providers to assist with the transition, which, in addition to providing a material, they can support this transition, even if they don't really want to. But I think contractually, this could be included in the agreement.
Thank you so much. So last but not least, Adrienne, you're going to walk us through contract term issues and due diligence. Thank you.
Hey, thanks, Tracey. And I like what JP mentioned. I think he had some verbiage saying when a contract is badly worded, things can go sideways. And that's exactly the lens that I'd like to approach our conversation today, but more so from a deals perspective. So I think if you were to speak to any deals practitioners that were in the market this past year, we would all share in the sentiment that this past year was a really intense year for deals, both in terms of volume and in pace. My team itself, we reviewed and advised on nearly 120 sale and purchase agreements this past year, and almost a quarter of them had some sort of deferred or contingent consideration component, but usually in the form of an earnout. And so because earnouts were so prevalent over this past year, I thought I'd just kind of walk through an overview of what we saw in the market, a few things to watch out for, especially if you're looking to structure an earnout, and some of the ways that we typically try and help our clients avoid litigation. So kind of just starting at the first box here, I know in the mining sector, often an earnout is structured around achievement of certain milestones or perhaps a royalty percentage on future revenues. Because we saw so many earnouts this year and it was prevalent across all industry sectors, in the end, EBITDA actually became the most common financial metric that we were looking at. And I think using EBITDA often it makes a lot of sense from a valuation perspective, but structuring and drafting an EBITDA-based earnout can get really complicated, especially where the target business becomes quite commingled with the purchaser's existing operations. I think typically we'd also seen earnouts ranging between a period of 1 to 3 years. And typically we would say that a shorter earnout period is often better for both parties. A shorter time frame tends to be less onerous. The seller can make a faster exit from the business, and there's often less time that the purchaser may have to operate within certain restrictive operating covenants as well, which I'll circle back to shortly. And then earnouts also require a lot of additional financial reporting and tracking requirements. So having a shorter time frame can reduce the amount of time that actually goes into those requirements. Kind of coming back to the restrictive operating covenants, we were starting to see a trend where sometimes the parties were looking to place a lot of reliance on having restrictive operating covenants in place. And this could be where the purchaser is restricted from doing certain activities, like selling a portion of the business or winding up the business during the earnout period. But I think one of the key issues with relying on covenants is that proving a breach of a covenant can be really difficult, as well as quantifying any loss that's suffered from that breach. So I think relying on restricted covenants alone could ultimately take the parties down the path towards litigation. What my team tries to do is avoid that and help structure an earnout kind of before you sign and think about all the issues up front. So in this middle column, just things to watch out for. And I think these things can broadly apply to any sort of financial metric that you're using when you're looking at an earnout or a component of deferred compensation, whether it's EBITDA based or revenue based. But you'd want to watch out for language being GAAP consistently applied. And I think this language can be quite easily misinterpreted between the parties. So the sellers may interpret this as being GAAP as they've applied it in their past practice, while the purchaser's interpretation could be like how they apply GAAP or even just a broader application of GAAP, again, which may cause differences in how the financial reporting kind of shakes out at the end of an earnout period. The other thing to be watching out for is kind of a generic or vague definition of GAAP. EBITDA itself and a lot of financial metrics that are used to track earnouts, they're not really like a GAAP term. I think while the components of EBITDA may come from, say, GAAP-based financial statements, the parties really need to be thinking about, like, are they referring to reported GAAP, or are they looking at an adjusted or normalized view of EBITDA or that financial metric to base their earnout on? There's also a few practical considerations when you're thinking about an earnout. I'd say often an earnout period aligns with when the deal closes, and that period is misaligned to, say, a target company or the purchaser's year-end period. So, like, you know, thinking through the earnout, how do you make sure you have proper cutoff and recognition of revenues and expenses in your earnout? And this is especially the case where if the target, maybe they're not overly sophisticated with their financial reporting, they may only make certain entries or adjustments at a quarter year end. So how do you kind of factor all those things in when you're actually doing a proper true-up of an earnout calculation? The other thing that actually was interesting and has come up a couple times, you know, what's the applicable financial standard when you're looking at doing an earnout? So I've heard of a case where the earnout was being measured under ASPE or accounting standards for private enterprises. The purchaser themselves, they reported under IFRS. So in this case, the purchaser had to actually maintain 2 sets of books over the earnout period, which again was very onerous for the financial reporting team. It just took up a lot of time kind of over that 2-year period to get through it. And I think in terms of, say, post-closing changes, something that I think needs to be thought through well in advance before you sign is, you know, what are the things that the seller should be like rewarded for or perhaps penalized for post-closing. You know, it wouldn't be fair for the purchaser to do a bunch of layoffs after closing, incur a bunch of severance costs, and then the seller ends up getting dinged for that in the earnout period. And then maybe even going back to like the commingled concept, you know, sometimes we see language in the agreement saying, oh, we're going to make sure we exclude synergies from EBITDA. But what does that mean? And like, what exactly is the synergy that you're trying to measure? And can you actually and practically separate and track that synergy so that you're not counting it towards the EBITDA calculation? So just a few practical components to keep in mind. In terms of ways to avoid litigation, and this kind of goes back to the point around, you know, there's reference to GAAP consistently applied. One way that we or my team tries to help our clients structure their earnout is actually introduce a set of principles, which is very clear as to how the various components of an earnout would be calculated. So in the schedule, it's a very accounting-based schedule, but there's usually a hierarchy that kind of outsets, you know, what would take precedence over what. We would typically use like a 3-tiered accounting hierarchy where we'd have very specific policies that can address good housekeeping items like proper cutoff for how you consider subsequent events in your earnout, which would take precedence over, say, like past practice is referenced in a very specific set of financial statements. And then both of those 2 tiers would take precedence over a broader interpretation of GAAP. And again, the intent is meant to bring all of these items up front to negotiation rather than having to deal with these things on the post-closing side and then ultimately, you know, go down the path of dispute or litigation. Another thing that we try to do to avoid litigation is to really make sure the agreement has tight wording around how EBITDA or any financial metric is actually being defined. So if we're thinking about EBITDA, like what are the specific adjustments or exclusions that need to be factored as part of that calculation? And this could be things where you have, like, say, a one-time gain on sale on fixed assets in an audited set of financial statements under GAAP. That's something that's part of EBITDA. Is that something that the purchaser would want to actually give value to or not? So again, it's one of those things that you're trying to figure out, should this be an adjustment? I think especially over the past year, we were seeing a lot of conversations around how government subsidies over COVID would be treated, whether or not that should be an inclusion or exclusion from your calculation of EBITDA. So yeah, definitely like a few things that were very interesting to see. I know we worked quite closely with our financial due diligence teams to really understand where there were risks and think about ways to structure the earnout to address those risks kind of in the drafting and before the clients actually sign their agreement. And then lastly, I would just say, like, for an earnout and specifically, just making sure that there's like a proper dispute process in place, very similar to when you have a closing balance sheet and a working capital true up. In those situations, like typically the purchaser prepares the calculation, the seller has a period of time to review it and can object to anything within that calculation. And then the parties kind of enter into a good faith negotiation period before going to a dispute. And this process would provide both parties an opportunity to try and like recoup value through a pricing adjustment rather than having to go through the time and cost of a formal dispute or arbitration process. So I think that kind of wraps up my section there, but happy to take any questions.
Thank you very much, Adrienne. I think just taking that last point a bit further, I think that's a really good point, because you don't want to have to start a whole litigation process post-closing related to an earnout provision and have to go through a lengthy, often multi-year period before you get finality. And I think we can have a whole session on drafting arbitration clauses, which maybe we'll try and do that next year. I see Rahat smiling. So we will potentially do that another time. But I think if you are having a sort of staggered provision, you want to make sure that there's finite time periods around that within which, if the parties aren't able to reach an agreement, there's some ultimate mechanism for resolving the issues, because sometimes if you don't have that finality, then it becomes unclear as to whether or not you can move through the next process. So those are all issues. One question for you, Adrienne, is when you have an earnout provision in an agreement, are there specific things that you find as a trend that people forget to think about or don't turn their minds to? To be honest, like this past year, I think there are a few instances where, again, this just speaks to the pace at which deals were happening. Sometimes earnouts were being introduced very late in the process. I had one client, we were working for the seller, literally 12 hours before the parties are supposed to sign, the purchaser from the US introduced an earnout. And so there wasn't a lot of time to go back and think through, like, how should this earnout be structured? And like, what are the key risk areas that we need to really cover off? So I think, like, if there is going to be an earnout, just making sure that there is proper time to think through the details and negotiate those details rather than having everything come up on the tail end, because ultimately I'm not too sure how that one will go. That client right now is in their earnout period, but I do wish that we had more time to actually properly structure that, because everything was so rushed at the tail end. So I would say, like, the biggest thing is just not overlooking some of the details and thinking, oh, we'll deal with this post-closing, because that's inherently when issues will come up. Thank you very much. So I don't know if anyone on the panel wanted to jump in on any of the topics that we've covered today. If they had specific thoughts or comments, feel free. But while you may be thinking about that, a couple of questions that have come up in the chat, and I don't know, Dani or Casey, if you can answer this one. Does the board and the company have an obligation of means or results in the surveillance of anti-corruption?
Yeah, I can start. I will caveat with the fact that I'm not a lawyer, but I will say what the regulators expect. So the regulators don't expect that you're going to prevent bribery or corruption in every instance. They realize the challenges with preventing that. What they will look at and what they do focus on is your conduct and how have you implemented the tone from the top and really permeated that tone as a board down through the organization. So how does senior management permeate that message down to its employees? How do they actively monitor what those employees are doing? Are they even aware of the risks, as I mentioned before, right? Very quickly, regulators can come into a business and they can get a sense of, are you actively monitoring for your risk, and are you actively creating a culture that is risk averse, or are you just simply turning a blind eye? So I think they'll look at those things more so than obviously whether a bribe ultimately takes place if you are in that situation.
Yeah, the legislation provides for a defense of due diligence, like a lot of the other pieces of legislation regarding your obligations with ESG or environmental requirements. So having systems in place that you are actively working on and auditing those systems, making sure that they're appropriately getting you the information you need to make sound decisions is important as a way of defending against claims of anti-bribery, corruption, or other ESG type claims.
Thank you. This, I think you may have already partially answered the next question in the chat, which is the extent to which a parent company may be liable for the acts of a subsidiary in a foreign jurisdiction dependent on location of the parent, and if so, what is the position of Canada?
Yeah, so sorry, was someone else going to speak? Oh, never mind.
Go ahead,
it
Dan.
is possible to for a parent to be sued in Canada. It would be fact specific whether the corporate veil were to be pierced, but it's not clear in every situation. I think the answer is, if you're going to have oversight of your subs, which realistically you need to for reputational reasons, you need those systems in place, kind of like Casey mentioned earlier, so that it runs through the entire organization.
Yeah.
And I think go ahead, Casey.
I was just going to say, and regulators know the ways in which the bribes are facilitated, and they know the impact of subsidiaries in these schemes, right? It's often not the parent company that's directing payments down to foreign officials. It's through subsidiaries. So they're fully aware of that, and there's probably lots of precedent out there.
And I think it does depend on different countries. Obviously, have different laws. In the Western world, I think we have similar legislation to other jurisdictions, but it might be quite different elsewhere. Anyone want to jump in on any of the topics we've covered in the 2 minutes that we have remaining? So we've covered a lot today. I want to thank everyone for joining us, and thank you to all of our panelists for excellent content. It's really just the tip of the iceberg, but hopefully we've given you some ideas for risk spotting and avoiding those risks when they do emerge, so that you can avoid litigation. And if you don't, well, at least now you have the phone numbers of a number of litigators, hopefully readily at your fingertips. And obviously we're always happy to assist if we can. Tomorrow at 9 o'clock Pacific time, noon Eastern, you can tune in for the next session, which is on trends in M&A, and particularly in the mining, lessons for the mining industry. So thank you all very much, and we look forward to the upcoming seminars.